morning. My name is Tatum Owens, and I'm a young Texan of reproductive age living in Brazos County with fewer rights today than when I was born. On behalf of Progress Texas and myself, I am commenting in opposition to Rule 165 today because I, like many others, feel that it failed to deliver a sense of clarity and guidance for medical practitioners across the state regarding what constitutes a medical emergency as an exception to Texas abortion bans. This is deeply troubling to me because I need my doctor to feel empowered to do what's best for me and required for my health and well-being. Texas doctors can't do that as the law lays and without your help paving the road to healthcare access. What I really want is those who can become pregnant and already pregnant Texans across the state to have access to equitable and accommodating healthcare. But that's not the case, is it? So I'll settle for you taking up the responsibility punted to you by our lawmakers and courts to ensure everyone's doctor can practice reproductive medicine without retaliation and save our lives. Our lawmakers surely won't, and unfortunately, we aren't empowered as patients, so it's up to you. Forced pregnancy in threatening situations is not an American or Texan value. I graduated to college last year, and my community and I are constantly debating about how we love our state, but it doesn't love us back. Some ones leave out of fear that there will be even more restrictions. Others rightly can't afford a pregnancy, unwanted or wanted. Like me, I literally cannot fathom being a mother where I am right now, and it is my choice when and if I begin a family. And the rest return to maternal health deserts where their lives would be threatened if a medical emergency presented itself, like they very often do, because pregnancy is full of complications and they could die, like Jennifer Alvarez Estrada Glick, only 6 years older than me, who died 2 weeks after Roe's overturn. I think about her a lot. The only reason she isn't here today is because of fear around administering reproductive health care. Her many medical conditions constituted a high-risk pregnancy, and yet out of 5 visits with her doctor, she was never presented with the option to an abortion. There will only be more people like her if guidance for doctors isn't issued, and I don't want to witness any more unnecessary deaths. Inaction cannot be accepted with Texan lives in jeopardy. We need clarity now on what the Texas Medical Board views as medical emergencies so doctors and patients can freely navigate access to reproductive health care. As it is currently, the definition is extremely broad, with no mention of the long list of conditions that complicate pregnancies and endanger lives. Your prompt action will save lives in futures. Please adopt rules that clarify the following. Clarify that the medical emergency exception to the abortion bans applies where pregnancy places the woman in danger of either death or a serious risk of substantial impairment of major bodily function. Key terms such as serious risk and substantial impairment need to be clearly defined as used in Chapter 171 of the Texas Health and Safety Code. The board should also clarify that a physician can provide an abortion as soon as they identify these dangers without waiting until life-threatening symptoms manifest. This must include already established judicial interpretations to help doctors make informed decisions when providing emergency care, especially regarding the inclusion of care for imminent death and doctors' reasonable medical judgment. For example, recent Texas Supreme Court rulings regarding the definition of medical emergency should be incorporated to ensure accurate understanding and application by doctors. I object to the wording of proposed 165.8A because it is likely to deter rather than foster physicians from providing standard of care abortions and medical emergencies. Physicians are already being deterred from providing such care due to the threats of criminal prosecution, up to life imprisonment, massive penalties, and loss of license. Meanwhile, Section 165.8B imposes excessive documentation burdens on doctors who provide medical emergency abortions. These requirements hinder standard medical care and complicate and delay critical care for pregnant individuals. State how physicians can ensure their medical judgments meet the standard for reasonable medical judgment required for a medical emergency exception. Provide the level of detail and legally sufficient evidence that must be present to substantiate a claim that an abortion was not protected by a medical emergency exception. Physicians face loss of their medical license, life imprisonment, and more than $100,000 in civil fines for providing necessary care. They need clarity regarding how and when their medical judgment will be respected before they will be comfortable relying on the medical exception as the legislature intended. As written, the proposed rules do nothing to provide physicians with reassurance that their judgment will not be second-guessed. Please review these additions and thank you for your commitment to protecting Texan lives. Thank you.
Thank you, Tatum. We appreciate your comments and you taking the time to be here today.